Good afternoon. Welcome to the second panel, Consumer Funding Regulation. Very excited to be here. Have a great panel put together, and I think we'll have a very constructive dialogue. Just as a small set of opening remarks, thank you so much to Eric Schuler and David Siffert and the CCJ and NYU for hosting this event and for the format that they're putting together, which I think will be building on from the very lively discussion in the first panel. So just as a small personal thing, well, to introduce myself, I'm Maria Glover. I'm a professor at Georgetown. I'm also recovering from abdominal surgery, so I may sit, I may stand, I may sit, I may stand, just to get that out of the way. In terms of how this panel is going to go, I'd first like to introduce the bill before we introduce the panelists, because the way we're going to approach this, I think, is to start with one example of a consumer funding bill, namely A115 in the New York Assembly. And we're fortunate enough to have an assembly member here to explain the genesis, the intent, the thought behind, and the content of the bill. And then we're going to broaden out the discussion into the regulatory landscape, the legislative landscape of consumer funding. And I will also, and the panel is well aware of this, exercise sort of professorial approach to making sure we clearly define our terms. Making sure, are we talking about consumer, and why would we call that consumer, and what makes up consumer? Would we call this commercial? Why would we call this commercial? What makes up commercial? Is there a third category, and my own bias, because I've said this, is there a third category for mass litigation that has a regulatory framework, to some degree, already baked in our mass litigation landscape of our rules of professional conduct, our ethical rules, and our rules of civil procedure? So as we go through this, we'll try to talk about the different things that come up in these categories and in the legislative responses that we're having to funding more generally. So with that said, I'm actually going to turn it over to Assemblymember Magnarelli to explain a little bit about the background of A115, and then I'll take a step back and have everyone introduce themselves and why they're here to respond to these legislative enactments about, or legislative proposals, I should say, to consumer funding.
Well, thank you very much. Is this on? Can you hear me? Okay. Thank you very much. I'm very happy to be here and for the invitation to speak on this panel. And I'm going to give you a little background about myself, which I think will also go to the intent of the bill in a way that was brought up in the last panel, how we get these things. I think that was valid, by the way. I really didn't take any offense to that. But you know, it's hard to listen to sometimes, being a legislator in the Assembly for 26 years. So I've been around a long time. First of all, I'm born in 1949, so I'm probably older than all of you in the room. I was married in 1970, had 3 children, 4 grandchildren right now. But my wife passed away about, after 47 years of marriage, passed away about 7 years ago. I'm a practicing attorney, or at least I was a practicing attorney. Right now, I am of counsel, but my area of law was real estate. Never a trial lawyer. Don't understand what the heck you folks do. But anyway, I did practice in a law firm that had a trial practice. I've been in the New York State Assembly since 1999, so I've been there a long time. In the Assembly, I met a colleague named Michael Simanowicz, and this bill really should be named after him. He initially brought the bill around 2017. He got it to the floor of the Assembly. It never was voted on at that point in time. The original bill that he had an interest rate cap that was removed by Michael to try to get the bill passed, but again, it was not voted on. Michael was suffering from cancer. And so was my wife at that time. And Michael would call me every week while he was suffering with cancer and ask me about myself and my wife. And then finally, during our discussions and our talks, he asked me if I would carry this bill because it meant that much to him. He felt, and this was the intent of the bill, the bottom line intent, the simple part of the bill, that consumers were being ripped off, that people were basically ending up with nothing after bringing lawsuits and having their cases tried. And then because of the amounts of interest that were owed by the end of the case, there was literally nothing left. So my staff and I took a look at the bill. By the way, we do look at these bills and we try to figure them out and what's going on. And I told Michael I would carry the bill. And he passed away. So, that's the genesis of how I brought this bill. I don't take credit for it in the sense that, Michael brought it to me. I want to make a statement here. This is consumer litigation financing. I'm not talking about what we just heard in the last panel. Although I understand what the arguments are and what was going on the panel, which I thought was very interesting, but consumer litigation has nothing, it's not the same ballgame, okay? This bill, 115, covers, like I said, consumer financing. Consumers are defined as a natural person. And the limit that can be lent under this bill is $500,000. So the constraints, basically, what I feel put it into a consumer bill is got to be a natural person, less than $500,000. There are certain contract requirements, rescission, type of print, being precise, setting out all the terms, the amounts to be paid, the charges, etc. Written acknowledgement of the fact that this was done by both the consumer and the attorney. No interference is supposed to happen by the lender in the case. It's in the bill. There is an interest rate cap on the bill that I'm carrying now, which is the military rate. I think that's about 35, 36%. Penalties. Penalties for not adhering to the bill would be no recovery of the money lent, plus up to a $5,000 civil penalty. You have to be a registered lender. You have to post a bond of $50,000. The reporting requirements are very important to me in the sense that the registrants would have to let us know on an annual basis the number of cases they have, the amounts that were lent, the percentages of interest charged, or whatever you want to call it, the fees and interest. And the Department of State is supposed to put together whatever other regulations are needed to make this law go into effect. So in a nutshell, I think that's what 115 is all about.
Thank you so much, Assembly Member. So that sets sort of the table of how this law defines consumer, the concerns it's trying to get at. And before we delve deeply into that, which we will, if everyone doesn't mind just introducing themselves briefly, what kind of brought you to comment on this bill and other legislation and consumer funding?
Good morning, everybody. My name is Brian Call. I'm with Libris Solutions. I serve as Libris president since January of 2022. We operate three core business segments, one of which operates in the consumer legal funding space under the brand of Oasis Financial. Prior to joining Libra in January of 22, I had over 25 years in consumer lending businesses, regulated industry, mortgage lending, consumer banking. And, you know, really my role today, I think, is to speak from a role of an operator who wants regulation. We want consumer protection. We think it gives regulatory certainty. But there are aspects of the bill and maybe alternatives for discussion today to try to find the common ground to ultimately have the bill pass and enacted. So appreciate the opportunity today. And also want to echo your comments earlier, just the forum and the format of this is spectacular. I think it's a model that other states should consider as we're working with business and elected officials to come together.
Morning. Good morning. My name is Brad Nail. I'm a partner with Converge Public Strategies. And I'm based in Miami, but I represent clients on regulatory and legislative matters in all 50 states. Those clients sort of run the gamut, but there is a bit of a focus on insurance and transportation and sort of startup tech generally. The ones everyone would have heard of are Uber, Airbnb, Enterprise Rent-A-Car. Those are the types of folks that I generally represent before the legislatures. Prior to doing full-time advocacy work, I did spend 17 years doing litigation management and claims management. So I have a background in certainly in the tort litigation. And I'm not here speaking for any specific client. I think, you know, I'm hoping that background and my experience in talking about this in the legislatures so far and in conference settings where we're trying to find solutions is helpful for today.
Good morning. Is it still morning? Maybe it's afternoon. My name is Gary Amos. I'm the CEO of Golden Pear Funding. We are a nationwide funding company based here in New York City. We operate in two primary focuses. We provide consumer litigation funding as well as medical receivable funding on a national basis. Prior to assuming this role, I spent over 25 years at Siemens Financial Services as CEO for the Americas in a commercial finance business, and prior to that at GE Capital. My hopes, my ambition, not only for today but going forward, much like Brian, are to work with legislators and in order to enact a more framework, more certainty, eliminate ambiguity, and find a path forward so that we can eliminate some of that that darkness around what we hear around this space.
So let's start, and this is, I think, a great transition from some of the discussions that were happening in the last panel where we heard anecdotes that came from the consumer space. We heard anecdotes that came from, again, I recognize not everyone would agree, but another category of mass claims litigation. We heard stories and bills about commercial funding, and of course commercial funding can subdivide into portfolio and single client and all of the things. This is a consumer panel, but I think part of the constructive way forward legislatively is to, as the New York Assembly is trying to do, clearly define what is consumer funding, who do you care about, what amounts do you care about, how do you define the terms and why, who exactly are we trying to protect, what are we trying to protect. That's a broad question, but I'm hoping and confident the panel is going to really dig in rigorously to how we're defining those terms, because there are different concerns that come up when you have different situations in the contract, in who's receiving the money, how much money there is, what are the things we should care about and why in those definitions. And I just want to turn it over to the panel to start moving forward on that.
Okay. Okay. Well, I think I already stated what the intent was. And we're looking to protect the little guy or gal. The idea is that someone who doesn't have the wherewithal to survive while bringing a lawsuit to either protect themselves or get compensated for a wrong and take care of their family during the course of a trial would have the wherewithal to do so. That's the intent of this bill. is to make sure that there are avenues of funding available that could help a person in those, in that area to be able to use the courts to have wrongs righted, so to speak. So that's, that is the intent of the bill. It gets complicated, but then again, it's not, as far as I can see it. And I'm just a legislator. I don't think it's as complicated as some of the other things we were talking about earlier today. It's kind of simple and straightforward.
I think it's a good bill to use as a jumping off point for this type of discussion because it's been around a little while, right? It's been vetted.
2017.
Yeah, it's had the tires kicked on it a little bit, and I think as I look at a bill like this, from my perspective, what I see are very strong consumer protections, right? There's language around the contractual requirements, there's disclosures to the consumers that are required, there's language, around control of litigation. Overall, I think it's a strong pro-consumer bill. I also like to look at sort of what I would call structural issues. What else is it addressing? What else needs to be addressed, and is it done? And I think the bill does address some of these structural issues. For instance, prohibiting attorneys from receiving a referral fee for something like this. Prohibiting finance companies from paying or accepting commissions or referral fees. Prohibiting law firms from having a financial interest in the financial companies and vice versa. There are a couple of things that it does not address that I would be advocating for. It definitionally, it sort of exempts what I would call maybe parent companies or affiliated companies of the finance company from any of these requirements. And my devious mind can concoct scenarios where people are able to exert certain levels of control and engage in this without then being subject to these regulations. It prohibits an attorney from having an interest in the finance company. It doesn't expressly prohibit the finance company from having an interest in a law firm, which I think is worth a discussion. And then there's a difference between disclosures and disclosure. This contains disclosures that are mandatory in the contract to the recipient of the funds. It doesn't address disclosure of the agreement, which we just spent an hour and a half talking about. And then finally, it doesn't address commercial funding, right? We're here to talk about the consumer side of things. But from my perspective, and let me just tell you, there was, I think, some debate on the last panel over what do we mean by commercial funding. In the public policy sphere, we've sort of split between consumer and commercial, right? And not subdividing the commercial side of things. Consumer means small dollar loans to individuals. Commercial means everything else. All right, so when we talk about commercial in this panel, that's how I'm going to be referring to it. My concern, and the Assemblyman can tell me if my concern is is not worthy, is that if this bill were to pass, and then we come back in the next session and say we still need to deal with the commercial side of the business, oftentimes we're told, we just dealt with this. We put this one to bed last session. We're not picking this up again. So that's why we would like to make sure that all aspects that we think need to be addressed would be addressed in a bill.
Could you distill that down to the couple of points you think that should follow along with this bill? Because I think what I'm hearing is the ownership, obviously within a law firm. What are the other like 2 or 3 salient points there?
Well, the models that we're developing tend to address the principal concerns, which are influence, which was discussed ad nauseum in the last panel. That is a concern for the folks that I'm working with. Just broadly, we see third-party litigation financing as fitting into broader judicial reform that we'd like to see, right? And it's one component of that. There are other things that are out there, paid versus incurred, use of medical liens, when those medical liens are used to inflate damages. This third-party litigation financing is one element of that. So, you know, I think the components, like if I were to pull out the in-coil model bill that we've been working on, that would start to address more point by point the elements that we'd like to see.
So to try to step back, what would be consumer funding, putting aside the concern that, you know, legislatures move from issue to issue, you spoke about how consumer would encompass these sort of, you know, offline expenses, living expenses to the client, but not necessarily law firm. But is that the dividing line? What are the dividing lines in consumer versus commercial? Because you could imagine, you know, law firm lending in a portfolio context of a consumer law firm. This bill doesn't seem to cover that, but you'd have trouble getting a legislature to pay attention to lit funding, much less consumer lit funding, if they moved on a bill like this. So can we continue to tease out what really should fit in the legislative priorities about consumer funding? Should it be as limited as this, or should it be more limited?
You know, there are certainly nuance, but I tend to agree with the Assemblyman that I think we can overcomplicate it. So we operate a business that operates in over 40 states. At its core, the recipient or the beneficiary of consumer legal funding is the injured party. Most often somebody who is either underinsured, not insured, or has an event happen to them where they're a victim. And they don't have alternatives. They don't have, I think this morning, the anecdotes of David and Goliath and rich uncle. Like there's not a rich uncle, and this is the David. And so we absolutely support a clear, level playing field to protect consumers, but also ensure we provide access to an essential service. So to make it very simple, we'll fund over 60,000 cases in 2024. The average funding size is $2,000. Put that in perspective to commercial. I find it hard to believe that a $2,000 funding is going to influence control. It really is ensuring the injured party has access to their legal rights while their counsel, effectively settles the outcome of their case. So the things that I've seen now over the last 3 years, and I can reconcile to my career in consumer lending, these are things like paying rent, putting food on the table, very, very basic living expenses. And from a funding in terms of estimated case value, we're typically seeing around 5 to 10% of the total case value that's being advanced. So it is not a windfall. It is absolutely a lifeline for somebody who needs our services in a time of need.
Yeah, I think to further support that, I agree with everything that Brian has added. We operate in similar states, but I'll speak more just to this region in New York City, because I think that's the context of where we want to focus. When you look at New York City, nuanced, yes, complex, yes, but when you look at how we advance and how we develop and de-risk the model of what we're advancing to a plaintiff, we never want to be in the position where we've advanced beyond what's reasonable. Okay, so then you ask the question, what's reasonable? What's reasonable for us is that we'll look at on a case-by-case basis and we'll evaluate the merits of that case. It's everything from a case type, the law firm and what their experience has been. It could go as far as the jurisdiction within New York City. All these influences make up for a whole host of things that fall into a risk bucket. From that risk bucket, we then employ the knowledge of personal injury attorneys that we have on staff that review the cases from a risk standpoint. And again, I come back to the core fundamental there is we never want to see a case, and Brian, I think you offered like 10% or so, which is probably right. You never want to offer maybe 10, 15% of what is the potential case outcome. We need to de-risk the strategy and de-risk any chance that we won't collect against that case, because we know we're not going to collect on every case. It's just it's a contingency, right? There's no fixed firm term. So I thought that's important to share so that it's in our best interest, it's in the plaintiff's best interest, and it's in the attorney's best interest that we keep, I'll call it a cap on the amount that we advance. It's extremely important. The final piece I'll add there is, Brian talked a little bit about, living expenses and where, and what are the merits of the advance. The merits are definitely that. It's household expenses, it's food on the table. We've gone as far as talking to plaintiffs and getting surveys done to truly understand, is that where the money's being utilized? Because we want to make sure that, without getting too ESG here, that it is part of that. Are we helping, the little guy or the little gal, in their time of need? But in New York City, you also have, workers' comp, you have PIP, you have other types of influences that may or may not help with insurance or medical expenses. So, Brian, you mentioned uninsured and underinsured. That's a big component of what we'll look at. And we see those requests, those requirements for uninsured and underinsured plaintiffs who have medical costs. So it's not just about personal expenses. Not every physician, I don't know if there's any physicians in the room today, not every physician in New York City will take workers' comp. It's just nature of the beast. They're either cash pay or wait to the outcome of the case. Well, we also can support that by way of consumer litigation. So again, it's a nuanced product, but it serves a few different purposes. And again, and final point there is we de-risk against that outcome, but still offer that support.
Brad, would you agree that the legislation about or regulation of consumer funding, we've seen one dividing line, which is fees versus expenses. Do you think that captures the market from your vantage point?
I don't know how I would define the term capture the market. I think that it doesn't capture every element of legislation that would be desirable, in as much as we still, I think, are interested in transparency. We're interested in the disclosure of the existence of these agreements, partly just from a general fairness point of view. I think as a former litigation manager, it helps to understand all the parties that are involved in a case. If I were a judge, we always hear, like, what is it, maybe 3% of cases that go through to trial, maybe less than that. And as a judge, my job would be principally to move cases toward settlement and resolution, and without knowing all the parties that are actually have some interest in the case, it just makes it more difficult to do that. Now, on the consumer side, we're still talking about low dollar, so that may be a more commercial focused issue for me, but I think it's still an element of the case.
But I guess, Brian and Gary, you're talking about hedging the risk and trying to help the little guy with expenses or the little gal with expenses. But I feel us circling back to a core element of the disclosure debate, which I agree with Amaya that we're going to look back and eventually we're going to have sorted out disclosure, but we haven't quite sorted it out yet. And one question that comes up from, we want the transparency, well, what gets baked into whether you give the $2,000 loan? Are you still looking at the merits? Are you relying on the law firm? Could you create a different economic vehicle that would get around the legislation if that were our concern? So to distill that sort of into, two basic questions, as you are deciding whether to invest and to put this contingency money forward to help the little guy sort of get through the expenses, to what extent is somewhat core work product at the heart of that? The merits of the case, the strength of the attorneys, the weaknesses of the cases. So that's one question. And the second question is, to the extent you're worried about transparency of a prejudicial sort that was defined by the last panel, would you create a different economic vehicle to get around that? So two-part question. That's such a professor thing to do.
I'll take a shot at question one. I can just speak from our experience. It's absolutely based on merit. From an underwriting perspective, we're evaluating a jurisdiction, in this case New York, the subcase elements, the experience of the firm or the attorney, the facts of the case. In many cases are, it's immediately after the date of loss. And so sometimes those facts are not yet fully baked and known. They emerge over time through a litigated process. That is the essence of our business and what we do, and I don't see that changing with or without regulation.
Is that going down my way next? Is that where you're
Yeah,
looking?
yeah, or anyone's. I mean, it's
So-
tricky.
Yeah, so, I think disclosure is always best left up to the Bar Association. I think our last panel addressed a lot of what the potential risks or headwinds are there, but I think the Bar Association should have an opinion on that. But I do think it puts a potential disadvantage to the plaintiff. The second part of that is that with respect, I also want to make sure I address the Assemblyman, that we do, just so it's clear, we do support legislation. I mean, I think we're all on the same page, here, Brian, from both of our sides. We support legislation. We want framework that creates guidelines. We're all for that. And with legislation, one of the things we talked about earlier, and the Assemblyman articulated, was in terms of the documentation. I mean, documentation is fairly transparent. It is extremely transparent. It is able to be rescinded within 5 to 10 days, I think is what we have in ours. And we don't go into any case where the plaintiff hasn't acknowledged the funding as well as the attorney. We require an attorney acknowledgement, and we require a plaintiff. So when I say, earlier I mentioned about risk and de-risking, it's not just us. We're de-risking it for the plaintiff. We're acting on their behalf. You sign, we sign, the attorney signs, and this is what we're looking at. So it's kind of, we triangulate the situation. We don't just look at it from our perspective.
I think one of the challenges that leads us to try to include some of the disclosure requirements in these bills is the inconsistency of the application. It would be, sometimes the legislature needs to step in and set the ground rules so that we're not getting different instructions, different outcomes from judge to judge. So that's one more element.
Do you see that happening often? Is that?
It's kind of all over the place right now.
Yeah.
Yeah.
What results have you gotten, and how do they affect, so if I find out, I mean, this rich uncle, right, would that we all had the rich uncle. What is needed about that disclosure? I mean, if I'm a little guy plaintiff, it may be because I have a small dollar claim. It may be because I have a hard to win aggregate proof type claim, like a civil rights discrimination claim. That doesn't say anything about whether I personally have a rich uncle. If I am impecunious and I need funding, whether it's from uncle or funder, what is the relevance to the litigation of the case and simply knowing if my living expenses are covered? And that's why I asked the question about the merits, because that is baked in. But if we're to we have this patchwork of responses from judges. What should judges care about when you're having this patchwork to set the ground rules?
Well, I'd like to just say, I don't think it has any bearing on it at all. It's maybe I'm being Pollyannic in a certain way, but I would think in most of these cases, because of the limits that are within the bill, you're looking at the claim. And I think all of this third-party litigation stuff, to be unlawyer-like for a second, is, missing the point. The point is there a valid claim? And what is before the court? And what is the court going to be looking at? What is the jury going to be looking at? And whether or not it's meritorious or it's not. And I don't believe that the lending, especially in these cases, has that much of a bearing on any of that. So my answer would be none.
And my answer is not that far off from that in terms of these small dollar consumer lending cases. As from an insurer's perspective, if I'm evaluating the claim, even before litigation or after it's gone into litigation, I am going to establish an evaluation range just based on the nature of the injury and the nature of the damages. And that is unchanged whether or not somebody has one of these, any type of financing or not. And I think that if I were to try to account for that, if I were to say, oh, well, this person must be desperate because they had to go get funding, and I tried to negotiate outside that reasonable range, I would be violating the Fair Claims Handling statutes. I would be opening myself up to bad faith by doing that. You know, there are, the defense side is quite limited in terms of how they can engage in that activity. And there are consequences for it. There are, in my experience, there's no consequences for a plaintiff's attorney demanding $2 million in every case, no matter what the, as an opening demand, right? There's just no consequences for that. There are consequences to an insurer lowballing someone outside a reasonable range. So it's not as relevant, because it doesn't affect my evaluation, it's not as relevant in this context. In larger dollar claims, it's certainly relevant to understand who all the parties are and what their pecuniary interests are.
Yeah, but the lender is not a party to the suit. And, you know, for that reason, to me, I don't understand how much disclosure would be needed, whether or not, if we're looking at, to see if someone is being influenced or has a pecuniary interest in the lender, you know, the attorneys especially, if anything like that were to be brought up, I would think that a judge, if they can't now, they should be able to take a look at those specific questions outside of the courtroom, outside of the jury, in camera, as we say, but without having, you know, a full disclosure or additional discovery proceedings on who the lender is and how much it just doesn't make sense to me in these cases.
And if the dividing line, one dividing line we've talked about potentially is fees versus expenses, single client versus different situations we're gonna put aside, but something else that's coming up is low value versus high value, right? If I'm discriminated against to the tune of a higher number, why does that make me any less David than someone who maybe worked there for less time or the discrimination was less blatant? I guess I want to try to get purchase on, if we're talking about little guy here, if that's a guiding principle for consumer funding, what makes them little? Does it make them that they're going up a big corporation? Why should it be claim value? Because you said you're more interested in it, right, if the claim value's higher. Is that the right dividing line? And the bill draws that, right, at $500,000. Is that the right dividing line? Because there are people, you know, I've worked on cases like this who are, you know, they're whistleblowers in workplace contexts. They have millions of dollars of damages, but they have no money. They don't have a rich uncle. They do need funding. They need bridge funding. They possibly need fee funding. I don't think that's any less consumer that, just simply because their case was valued at over $1 million, because they don't have $1 million. So why is that the dividing line?
Well, we're not talking about the claim, we're
Yeah,
talking about
advance.
the
advance.
we can't call it the advance, I can't call it a loan, I keep wanting to call it a loan. All right, so I think that's the difference. I mean, you could be suing for millions of dollars. The question is, what is your need in order to avail yourself of the courts? And that's what we're looking at.
Yeah, so exactly right, because I think that line of demarcation at $500,000 is the advance by, you know, us as funders. That's an anomaly. I mean, where you see that happen. I mean, I'm not sure I can think of many over the last, and I've only been around this space, you know, the last 4 or 5 years. But yeah, case outcomes definitely do run into those settlement values of millions of dollars, depending, especially in New York City.
And that's helpful. I mean, I agree, it's sort of a simple point in the bill, but it doesn't come out a lot in the discussion of where we draw this line. Is it case value? Is it advance value? It is, you know, how is it factored in?
Well,
Sorry.
and Maria, I think that's why in a lot of the legislation that we're seeing, it is hard to draw a line that makes sense. So we tend to try to apply the same rules to the low dollar consumer lending that are applied to the high dollar, what we're calling commercial side of finance. I said lending, sorry, financing. You know, we've certainly, in trying to negotiate compromises I think that there's some solutions out there that will alleviate the concerns of some of the small dollar lenders, financiers. But it just takes sitting down and getting through the negotiation process on a particular bill. On the disclosure piece, I think we're actually closer to finding a solution with the consumer side than we are on the commercial side.
And shifting from disclosure to the key sticking point of the bill, right? It comes in a consumer protection lens and effectively caps the interest rate. And Assembly Member, if you could speak a little bit about that pressure point and how it's playing out politically.
Well, behind the scenes kind of discussion here. I have taught a course in the Maxwell School about New York State government and politics, and this is going to be one of my prime examples of everything that comes to bear on a piece of legislation, and from all sides, places you wouldn't even think of it happening. The interest rate thing is basically, you've got a bunch of advocates who feel that the interest rates, or whatever you want to call it, the charges or whatever, the bill makes a distinction, are too high. And as I said at the onset, consumers are being ripped off and being taken advantage of by bad lenders. If you read the sponsor's memo for the justification for the bill, and again, this is mostly taken from Michael and not from me, but I'll give him credit again. Consumer litigation financing emerged as an industry in the U.S. in the 1990s. Currently, the industry is not regulated in New York State. As a result, a number of bad actors entered the business, who often acted in bad faith and charged exorbitant fees for the services provided, and engaged in other bad practices. The instant legislation provides a set of robust provisions that, if enacted, would tightly regulate the consumer litigation financing industry and protect the consumers of such services. So, I mean, that, again, is where we're coming from. And going back to the class story, we have been inundated since I took this bill by, let's put it this way, the lobbyists or the advocates on both sides of this equation, relentlessly. When the bill looked like it was getting some traction, about a year ago, I think it was, not only were the lobbyists in the hallways in full force and waiting at my doorstep, but also they had clergy from the minority communities within New York State on both sides. One set arguing in favor of leaving the interest rates alone, the other arguing that they should be capped. You know, the bottom line on all of this is access to the lending, okay? Will we be cutting it off? That's the line. That's the thing that I feel is the crux of this bill right now. Not that disclosure doesn't become involved in it, but I think that's secondary to how much can I charge? Are you going to put limits on me? Will that have an effect on this industry? I think that's what's causing the problems with the bill at this point in time. And, you know, leadership in both houses has changed over the years. Bills advance, bills don't advance. And a lot of it has to do with what's happening with the advocates that are roaming the halls.
So just to turn it to the panel, one, how do you set an interest rate cap if you, two, set an interest rate cap given the risk of the investment? And of course, we all have in the back of our minds, the payday lending industry. So how does a cap work with how you're thinking about valuing and lending and taking on risk?
I think of two things come to mind immediately. One, I think it's altruistic. I think it's the right thing to do. We absolutely support regulation and protecting consumers. I think where, at least in my experience and interacting with elected officials and trying to explain, compare, contrast consumer lending vehicle product versus consumer legal funding, there's some obvious differences, right? First, the non-recourse nature of litigation funding. The fact that through non-recourse, that on average, and these are our own kind of statistics, but also companies that we evaluate in the industry, some variance of 7 to 10% of cases will be a zero. There's no debt created, there are no payments, there's no recovery. It's an absolute zero to the lending institution. Secondly, of 10 cases that we would see, or also competitors would see, of 10 cases, so you're getting one of those generally as a zero. You're also seeing 3 of the 10 where at the time that funding was advanced, the estimated case value in its realized state is less than what you estimated at some point, typically 18 months, 24 months prior. You add to that a duration, because there's not debt created, there are no payments, there is no recourse. We, from just an economic perspective, the kind of the curve that we recognize, we'll see cases settle in 1 month, but we also see cases settle in 8 years. Okay, so that kind of coupled with just the simple economics. Okay, so call it 10 to 12% loss rates. Companies in the space, even those like Golden Pair, Libra Solutions, who are sophisticated, I think we set the bar to do it the right way in full disclosure, transparency. Cost of capital, you're talking 10 to 12%. Okay, then you have a cost to run your business, 10 to 12%. Well, you don't have to be a math major or a finance major to have 12% loss rates, 12% cost of capital, 12% cost of operations, and your maximum rate is 36% annually, okay? So there's just simply from the viability perspective, what we're passionate about is access to the product, transparency to the consumer, the co-underwriting feature that Gary spoke about with the attorney is so important, right? Think of any other consumer lending type product where your attorney by obligation. We will not fund that contract without the attorney's consent for funding, that the funding is right, both the amount and the circumstances by which the funding is asked for. So one, it's just economics for me are not tenable long term, which I think restricts access in the immediate, even for the largest and most sophisticated funding companies in the country. What we have seen in some other states like Utah, Oklahoma, Vermont, is starting with reporting, and the Assemblyman spoke to that earlier, is we believe having clear operating lines of licensing, bonding, routine exams of funding companies that are registered in the state. We think that's a starting point, and believe that exposing your books, showing to the department as part of routine exams, the economics, I think, is a starting point where we have found it encourages free market, competition, and through competition, we start to bring pricing down. Absent that, I think you do have bad actors, right? You have those who are kind of operating on the edges and maybe even intentionally operating outside. So again, for me, it's the economics are not tenable long term, and I think there's an alternative to get tighter on reporting to encourage free market.
Yeah, and I think all that we share the same view for sure. There's no doubt. Take it one step further, right? You want to also remove the element of bad actors. How do you do that? And like the Assembly member has shared with us, there are ways to do that by enacting legislation that also has bonding, background checks. Take Nevada, I think, is another example. Nevada has a pretty exhaustive process in order to be a funder and have a shingle in Nevada. I think ours probably took 12 months, 18 months. It was a very long time. It's an exhaustive process. There's a whole lot of information that's shared, even personal information on the exec suite of the funding company, albeit I don't own the company, but I sit in that chair. So that adds a level of, I think, validity to what we're trying to accomplish and what the legislators were trying to accomplish in Nevada. Now, are you always going to eliminate every bad actor? Maybe, maybe not. But that in and of itself eliminated a tremendous amount of funders right off the bat. They couldn't make it through the process. They didn't have the financial wherewithal. They didn't have the representation to go through the process. They couldn't offer a bond. They couldn't pass all those hurdles. So Assemblymember is spot on. When you go through that process, you eliminate a lot of folks that may not be allegedly above board in order to be operating in a business that folks like Brian and myself advocate for the legislation. And we see a level, again, Brian, 3 years maybe for you, maybe 4 or 5 for me in this space, both coming out of institutional America. I've seen a level of maturation in this industry pretty significant in the last few years. When I first got here, it was much different. I think it's different. It's much different now with folks. Not that we're making all the difference, but I think how we're set up, what we advocate, and working across the aisle with legislators will help us get there. Like Nevada, like I think it was Vermont, Brian, you mentioned the transparency there. That to me, as someone who's run larger financial institutions, in order to back test against what that data is telling you over a 4 or 5 year empirical evidence is something I think is invaluable for folks like the Assemblyman to look at in 3 or 4 or 5 years out and say, what is the real rate, if there's an argument against rate of return, or are we realizing with significant levels of losses against reserves and bad debt, because the correlation here is not a loan, right? We don't have collateral to marshal. All we have is the good faith of a case being settled by 2 or 3 third parties that will hopefully settle this case in the right way. So, again, in summation, we support it. There's ways to set up the framework. Other states have demonstrated how to do that. But let's also be mindful that we should look at some empirical evidence over a handful of years before we rush to judgment.
I assume you have a response.
Well, I mean, the question is interest rate, right? And
Yeah.
should it be should it be capped, and at what level should it be capped? And, I try to stay in my lane, right? When I worked for Uber and we were passing insurance requirement bills all over the place, and legislators would ask me, what should the taxi requirements be? And I would say, that's not my business. That's a different industry. I'm not getting involved in that. My perspective on the business side is the interest rate decision is better left to the policymakers, and I don't have a strong position on it. But they ultimately are the ones who have to balance.
Then what are all these people in my office?
They're not me. They're apparently consumer advocates, is my guess.
No, they're industry
Or
advocates, too.
we can talk about the process a little bit and why some of them are in your office, which is that it's an opportunity to negotiate other elements of the bill that they really want, and that they'll ultimately give in on the interest rate when it comes down to it. And that's the give and take of the legislative process, right? Okay.
Could be.
But I think that I represented a client who was in a more traditional lending space, actually, a lender who was trying to expand their business into a higher risk segment that there were some substantial benefits to those folks that they were going to lend to, but it required a higher interest rate, and sometimes higher than the statutory cap. And so they made a good argument for doing that. It was unsuccessful, but just from a pure math business perspective, they made a good argument to do it. From the context of these bills, I trust Brian. I trust these guys that the financial details that they're spelling out are true and correct, and that it becomes a lower margin business than one might believe, and that needs to be taken in consideration. But ultimately, it's his job. He's the one that's got to balance the consumer interest with the business interest here.
True.
I mean, is the interest cap, though, the right lever? I mean, obviously, people want to get other things in the bill, but just assuming, I think I hear you from at least 2 people, you don't think the interest rate is where to regulate. Am I correct in that? Just to not have a number, or am I mishearing?
Oh, there's a lot of jurisdictions that don't have a number. And, and I've taken a good look at those. And one of the things that you mentioned, and I know especially young people love to say the word data. We don't have enough data, okay? I agree on a lot of things. We don't have enough data. We could be collecting data forever, okay? But there is a wrong that's happening. And as you said, that's my problem. This wrong needs to be righted. And so we're trying to do the best we can. As far as, the interest rate question itself, and the data, I'm looking at, with my staff, should we do this as a pilot? Should we sunset it after 3 years, 5 years? I'm just worried that everybody leaves the field and doesn't lend for that period of time, and then I'm really in trouble. But if we set an interest rate that is reasonable, that we feel is reasonable, and then take another look at it, or have the Department of Financial Services take a look at what the rate is. Should it be lower? Should it be higher 3 years from now, 4 or 5 years from now? Are we moving this along in that way? We're looking at it.
Yeah, and my worry, which again, I think it's well-intended, and if we were talking about a consumer lending product, I think we could get behind it, right? I think the way we would view it, drawing experience in other states, or states that may be taking a more bullish stance on rate caps versus disclosure versus, licensing and bonding requirements, independent board, et cetera, is our recommendation would start with, let's get a full disclosure of the fully burdened expenses and the net income contribution of a consumer legal funding business in the state that operates in the state.
You mean data,
Yeah,
not disclosure, but
but yeah, but full disclosure, right? Full disclosure, and it could be independently audited financials, third-party produced financials, because then again, there could be you could see a scenario where those financials could be altered, right? There may not be the best faith. But we do believe, we've seen that model in other states work to actually bring rates down, because now you have funders who want to be in the state who will compete, and free market then determines the right interest rate relative to the risk. Because even if we were to contemplate 36%, if you didn't believe maybe the math I just walked through a few minutes ago, the unintended consequence, or maybe the intended consequence from an operator's point of view or practitioner's point of view, is we would only then look at the least risky cases. And the consumers who actually need our help the most are the ones who are left behind. And so that is an unintended consequence, okay? And also, too, in the duration when they need our help the most. Typically very close to the date of incident, or catastrophic cases where there's real medical, surgeries, there's a lifetime of recovery, and we are no longer able to provide funding to that injured party in their time of need. So that'd be an argument, I think, for me, that I get concerned about in terms of access, or what we would evaluate as a private company contemplating operating in New York with a 36% cap.
And I would say, actually, Brian just said something that I was going to say as well, is it's easier to make the justification, I think, for this type of consumer lending, because you really are, it is the broader access to justice question. It is the need question, that they can answer that. And then the Assemblyman in his initial remarks on this topic pointed out, what is the possibility that we're actually foreclosing access by setting a lower interest rate, right? So these are the balancing, and I don't know how you get to the right answer before you just dive in, right? You just got to pick enough, and maybe there are enough states that have set some of their only handful right now, right? But there are a few states that have set a limit there, and maybe we can look at those and see what the impact on the market is, what the impact on both the finance companies and the borrowers looks like, to make an informed decision. But we're still probably early enough that it's a bit of a guessing game.
Well, and for scholars trying to do research and to build on something Assembly member said, that we can collect data until the cows come home, and that's not to insult data or the cows, but there's a point at which, A, are you getting data that's helpful? Because we live in a country that, for now, has a system of federalism, and I'm just gonna do business differently. I'm just gonna do business elsewhere. I'm gonna rearrange around the regulatory landscape, just like I always have rationally should have done. And so, is it data we need to decide whether the interest rate is going to be the right lever? Because, to your point, higher risk cases are the obvious ones that fall out, and maybe we want those higher risk cases in. Is it an auditing process? What is the lever that if we just said, look, the data isn't going to be what we hope it's gonna be, but we want consumer lending to be fair? Do you go with the interest rate, or do you just move states, or do you come up with another lever?
Well, you're not, yeah, I mean, typically you're not gonna do, what I sort of hear in there was, you know, a risk-based pricing, or you can do risk-based pricing and just selectively choose, okay, these cases are at the peak of the interest rate, and then, you know, do the waterfall down. You're not gonna do that. That's just kind of unfair business practice. You would never do that. The challenge that you face, and I think I heard someone say it in terms of duration, New York City is just a longer process. And add in all the other complexities of the courts here and the backlog and pandemic and everything else that went along with that. But at the same time, if what is depicted or what folks are trying to say, well, this interest rate is high because it's documented at X and Y on the contract, again, remember what Brian and I are saying. There's 2 or 3 other headwinds, nuanced headwinds in there that are affecting the ultimate return on that, which is the case value anticipated, there's compression. We've only lent up to a certain amount, or advanced rather up to a certain amount, as I articulated earlier. Well, that just came down. So when you look at these influences, we really need to look at the cows or the data. Let's throw them both in that same bucket. But I think we really do need to consider looking at that before we say, okay, let's just point to rate. For me, I don't believe it's just that's the topic. You need to look at everything influencing the return over a period of time in a jurisdiction and say, okay, that's ultimately what has been born out of this product at what rate. Because rate is a superficial term. We don't have and we're not alone. We don't have any collateral. I mean, we've said everything, you know, a few times now, but it's completely different, and we have to draw that line.
Just 2 more quick things. You asked what is the lever?
Yeah.
There may not be a lever. We may be building the plane in the air, right? And so,
Boeing does.
and I
You
think
do it all the time.
Yeah, I was just about to say, this is how we make laws, is that we figure it out on the fly.
Oh.
And sometimes you just have to pick the interest rate is maybe the component of this that is easiest to digest and easiest to get people's heads around and to put into a bill that will pass. And what the amount of that is going to be, I mean, right now, I think you said it's tied to the military rate.
Yes. This bill is.
There are ways to anchor it to known rates. That still doesn't necessarily mean that it's going to be right for this particular type of transaction, but we just got to pick it up.
You know, there's other things that have been considered too. I was, because my Speaker of the Assembly is a very close friend with the Speaker of the basically the Assembly in Illinois. I said, let's take a look at the Illinois bill and see what they did. And, you know, they kind of, they charge interest every 6 months, and then they stop it after a certain amount of time. And, you know, they have a whole different way of looking at it. So, you know, we're willing to look at things like that as well and try to come up with, you know, something that would be palatable in the long run to lenders, because we do feel that lenders are important here, obviously, and you know, but we're also trying to take care of the consumer.
Yeah, and that's,
so all
that's
of this
the whole
stuff
thing.
is being looked at.
Yeah, because that's a good point, is that when you talk about, you know, rates stop after a certain period of time, or they're charged every 6 months. And again, remember, we would agree as business people, APR is a materially different animal than what we do. Materially different for a whole host of reasons, but not to exclude that if a settlement should occur in month 3, month 6, month 9, in the first year, maybe in 18 months, which some do, all bets off on an APR. That just doesn't work.
One alternative I heard come up, and maybe it's an in addition, but some sort of licensing, bonding, vetting process. If you're a legislature trying to, because regulation is legitimizing, right? So it's not that everybody here's anti-regulation, we're trying to arrive at the right one. So what protects consumers and legitimizes the industry? And so let's put the interest rate aside just to flesh that out a little bit more. What would that specifically look like? Like a licensing kind of requirement that you go to?
I think this bill is a good beginning for that in terms of requiring that the lender be vetted in the beginning, that a bond is posted, et cetera, that there's reporting. Hopefully we'll be able to see whether they're a good actor or a bad actor, and putting it under the Department of Financial Services or the Department of State, I think, in the bill, to take a good look at these things. I might have misspoke in the beginning. I think it's the Department of State that would do the regulations. But the bottom line is, I think the bill is a good beginning. Yes, we are building airplanes in midair sometimes, but at the same time, we're always looking at it, and we're always trying to make sure that it's better. That's why I'm here today, by the way. Not to give you what the bill is all about, because I think you can read it. Okay, it's pretty simple, very straightforward, but to listen to all the other things that are involved in this area, and to hopefully get some good information that I can bring back to staff and see if we can make this bill better. I'm all for it.
I want to make sure we leave, we said we'd leave 20 minutes roughly for questions from the audience. Does anybody else on the panel have anything to say before I think it was a great segue into getting feedback. Does anybody on the panel have any last words?
They can wait.
Okay. Tony.
Okay, so this was really interesting. I'll try to keep my questions short. It's got 2 parts. First of all, I have studied this, and I think that consumer protection is really important. I want to stress that consumer protection has multiple different expressions in legislation. So, I was just thinking consumer protection in finance, for banking, how much consumers pay for their banking. Consumer protection in fraud, whether or not they're defrauded by sellers of products. Consumer protection in lending, how much consumers might pay for a recourse lending product like a mortgage or a credit card. And then consumer protection in, against monopoly, how much consumers pay because of antitrust by sellers. Not all of those involve the same kind of protection. I did study, as you may know, what I thought was a pretty good slice, 10 years of a very large tranche of consumer litigation finance contracts, 60,000 completed ones, 100,000 offer total, but 60,000 completed. Discovered that the ex-ante cost to the consumer was about 43% per annum. The ex-ante rate of recovery to the provider was 43%. That's not too far off from 36%, so yeah, maybe we should just go 36%. But I'm not comfortable with that. So let me make the second point. This is definitely not consumer protection in the context of lending. It's something else. And so I want to emphasize that the word interest is quite misleading. This is a price control. Now, I teach torts. I teach PI cases. That's my main job. I only do legal ethics on the side. Take a $20,000 expected value on a PI case. The funder that I was looking at, 10%. So it's actually a $2,000. Actually, the median is $2,400. Let's call this one $2,000 advance, okay? Let's take that $20,000 case. 30%, not 33% contingent fee. $6,000 fee to the lawyer. So we're talking about a $14,000 net on the expected value of the case. I have a question for the panel. Here's my question. If I told you that the consumer knew in advance it was a 12-month to date of expected payout, because our result was 14 months actually in the median, let's call it 12, okay? And we tell them, listen, the rate's not gonna be 43%, or it's gonna be 100%, which is often what it looks like on the contract, although it's not actually when it gets paid out. 100%, okay? So that means I give you $2,000 today, in 12 months you're gonna get $20,000, $6,000 goes to your lawyer, you give me $4,000, okay? That's one contract. What's the difference between that and going to the consumer and saying, listen, 12 months from now you're gonna get a result, 20,000 net. Oh, sorry, 20,000 gross. It's gonna be 14,000 net. I'll give you 7,000 today, okay, for the entire amount. Now, it's true that New York law doesn't let you assign a personal injury case, but you know, you can assign personal injury cases in other systems. Let's pretend we can do that. I'll give you $7,000 now, 100% of the value of your case. That is a 100%, right, rate of return to the funder. But I promise you, nobody would think that we should step in and tell the consumer what they could sell their lawsuit for. But for some reason we say we can tell the consumer what they can take an advance for. And I don't understand that. I still don't understand that.
Well, I don't drink and I don't take drugs, but I love to gamble, and that sounds a lot like gambling. So I'm all in. But it also sounds like analogous to the sale of life insurance policies, right? And I think we in this room might assume that people can make rational decisions, that they can account for all the contingencies, and that they can arrive at the right result. But you know, not everybody can do that. And so laws are passed, regulations exist to protect those consumers who don't have the knowledge, who don't have the ability to protect themselves in cases like that.
Yeah, and I think that's the point. You're talking about a person's right to make a determination for themselves. I get it. That's fine. But is the playing field flat? Does that person really understand what he's doing? Is he being represented? Is the contract being explained to him? Does he know what he's giving up? It's very easy to say, he's going to get $7,000 versus $14,000. Does he know that? Does he have any idea of that? And I'd say the answer to that is no, and that's where we come in.
So, I'm, by definition, or maybe I'm a contrarian by nature, so I like kind of thinking differently about the industry, right? I can only think about the challenge of that kind of concept. One of the guiding principles of companies, we've talked about bad actors, but the good actors, the companies like Gary's organization, other organizations who I think do this well. They're committed to regulation, they're committed to transparency to the consumer, they're committed to minimally funding cases, meaning really assess the plaintiff's need in the immediate for necessary living expenses, whether it be their medical care, whether it be to pay their rent. And I think the unintended consequence of a version of what you just outlined is now it's maybe that windfall. Right now it is more of, you have 7,000 today. Is there enough? Because it's not just 7,000. Believe me, we say no more than we say yes. It's, from just think about consumer lending type businesses, we really evaluate the necessity, the essential need for the ask. And, Gary talked about a golden pair where they'll actually do a voice of customer to understand is the intended use case being used for funding. So for me, that would be the unintended consequence, is now you've given 7. Well, now it's going to be, can I get another 3? Can I get another 5? No, we want to make sure we understand the basis and fund that minimally, because we think that's the responsible thing to do, absent an alternative.
Yeah, I think, you said it best about drinking, and what was the other comment you made? I think, betting on the outcome of $7,000, to me, that's like saying, I'm going to advance you the value of your home in 20 years, not what it's worth today. I mean, it's gambling. I mean, that's not what we do. That's not what we advocate. I want to, again, not only de-risk my investment, but I want to de-risk your investment as well as the consumer in full transparency. So I don't know if I answered your question, but I don't see I don't see the two examples that you described, and you described them very well. I see them as completely different. One is a complete gamble, but one is acting in the best interest to limit the risk for all parties involved. That's one man's opinion.
And I know you're using a, kind of a hypothetical example, but I think it's important because sometimes we'll evaluate on a single case level, a given single case, rather than thousands of cases that a funder will go after. In that example that you use of a $20,000 value, advancing or funding $2,000 to the plaintiff, accruing to $4,000, that certainly can happen on an individual case level. In aggregate, what really happens is that $2,000 in aggregate maybe accrues to $4,000. The realized outcome is around $3,000 because of losses and those things. So it really ends up being so you're providing in the time of need when they need the medical care, they're closer to the date of incident, they need funding to pay rent today to really have realized the real value of their case in the litigated event. So I just want to call that distinction.
Question up front.
Okay, so really dumb commercial litigation funders, so maybe my questions are really basic, but listening to all of this, the Assemblyman seems to be coming at this from a let's protect the consumer viewpoint, right? So a couple of questions. One is, I think the way these contracts typically work, right, is you go and you get funding and you guys give the plaintiff some money up front. So one question I have is, why do you care about bonding? Because honestly, I'd rather you go under, because if you're not here in 2 years and my lawsuit finally settles, I don't have to repay anyone. You're gone, right? So why do I care as a consumer about bonding of your product? Two is, Gary made reference to, okay, well, we disclose and the plaintiff has to know that this is happening, but that's like reading the terms and conditions of your iPhone, Apple Care, right? Like, have you guys ever thought about providing, because we even do this in commercial, we don't love doing it, but we do it, like a calculator, like they have for student loans now, so that consumers can actually see what they're getting themselves into. And then finally, last question for Brad is just about the access to justice element, because I guess I'm just thinking about this, like you are a plaintiff, you had some horrible thing happen to you, you're waiting for a settlement, you need some money up front to pay rent. I mean, that lawsuit, the justice is happening, right? Because that lawsuit's going to happen no matter what. I'm not sure it's really an access to justice issue. And in general, I don't like price caps either, but that's a whole story. That's why I think a calculator would be a more effective. So I'm curious if you've thought about putting a calculator in your bill. And
Intuitive, right? So,
yeah.
I mean, just for like level setting, we do it today, right? So we disclose in 6-month increments today.
Yep.
And for the duration, in many cases, 3 years, I mean, it's for an extended period of time, what the total payback would be. So as they sit with their attorney, who's assessing relative value, helping to administer their medical care journey, et cetera, the plaintiff and the injured party understands this is my total of repayment at various intervals throughout the process. So that's not a new process. We do that today.
No, and the bill calls for that.
And we support
It's
that.
got to be written.
Yes.
It's got to be in the contract.
In simple terms.
And the contracts are as complex as your iPhone. Yeah, they're as you just said, they're very straightforward. There's not a whole lot of ambiguity or complexity there, and we do require the attorney to sign as well.
What does the bonding do for anyone?
Well, I think from and Assemblyman, I'll leave that for you as well. But obviously, if you're looking to remove some bad actors, there's a whole host of things you do. That's just one tool, I think, in the toolkit in order to remove a level of bad actors. They're probably not going to go through that
Part of
process.
the vetting of the the people applying to become registered lenders in this field, just to set some kind of standard. Maybe it's too low.
Yeah, I mean, like I said, Nevada was. I mean, I thought they were going to ask for my firstborn. I might have given it to them, but.
Fun fact about that, the reason why they have that whole crazy process is there's a long history with the casino industry.
I totally know. Yep.
They avoided
Yeah, but look, that's just one of many states that have gone down that road. of vetting and offering that, not just because of the casinos, but point well taken.
And as to the access to justice question, Gary or Brian might be better suited to talk about that, just because that's sort of one of their talking points of the consumer industry is allowing the little guy, little person, the chance to not have to not let their personal financial situation dictate their decisions within the context of this potential litigation.
Yeah. Good summation.
Thank you.
I think Victoria has a question.
Thanks so much, Maria. Really fascinating panel. Thank you so much to everyone for your insights. I wanted to ask about the question of desperation. In the consumer context, which is different from the commercial context, even when a business is facing challenges, the people, individual people in the business, for the most part, are not desperate, at their wits' end, willing to seek money wherever. And many of the consumer clients are actually in that place. And so I'm curious as to whether the disclosure requirements or the other features of the legislation are really dealing with a person sitting down, you explain everything to them, and yet they're still so desperate. It doesn't matter what you explain. It could be firstborn. You got to give me your firstborn. Sure, just give me the money. I need it right now, today. How do we handle that situation in terms of consumer protection?
Well, I can't fix everything, no matter what he asks me to do. So, you know, the bottom line is, I don't know how to answer that question in any other way. If a person is that desperate, you're right, they're going to sign anything. But what we're trying to do is set some standards, some disclosure requirements, so that an attorney will go over the written contract that they have to sign and say, by the way, this is what you're going to have to pay at the end of this case if, in fact, we're successful. Okay, and by the way, if we're not, you don't owe them anything, which is something else. You know, that's, there is no way to answer that.
Yeah. What can you do via legislation? You can't account for every scenario. And so again, in the balancing of interests, if it were so abhorrent that those cases occurred, then there might be momentum to just outlaw the practice altogether.
Correct.
But there's, I think the perspective is that there are too many benefits in the routine issuance of this types of financing. And look, you just can't deal with every contingency in legislation.
That's right.
So I'll just end, because we're close to lunchtime, with one last question that's a little broad, but I think it brings it back to the fact that this is a mixed audience, it's a mixed panel of finance on both sides, legislators, and now let's bring it back to the lawyers, right? We're at NYU Law, so let's bring it back to the lawyers. What is the role? Because if I'm a consumer, desperate or otherwise, am I really the consumer of this product, or is it the law firm recommending a particular lender that they use, a particular set of lenders? And so I'll just leave it. Is there a role in legislation for thinking about the interplay between the repeat player lenders, the repeat player law firms, and these one-shotter consumers in terms of who is actually the consumer?
Well, we try to handle it in the legislation. We try to make sure that the lawyer understands the ethics that are involved and that they can't refer to certain lenders, et cetera, et cetera. I don't know exactly what else we could do besides putting that type of language in the bill. So.
Yeah, I think there are prohibitions against referrals and that sort of thing, but I feel like the question maybe goes to the broader overarching question of just this type of business in general, and that is probably more properly addressed in the big commercial standpoint, which is, do we want to turn our courts into just another marketplace? Do we want to turn our civil justice system to allow the securitization of lawsuits and turn it into some speculative market that people are playing in? I think that's less of a factor in the small dollar consumer lending space. I think it's a bigger existential question that should be asked in the mass tort. Maria has an excellent article on mass arbitration that everyone should read that is really interesting. And I think in the first panel and here today, we've just sort of accepted as our starting point that this lending exists, or I'm sorry, the financing exists, right? And so what are we doing within that context? And we're not really asking ourselves, is this actually good that this exists in the net, right? As you weigh out all the factors.
Or how far down the road are we already,
Yeah.
such that this is leveling a playing field that's already been paved? And so that's sort of the existential broader, where do the lawyers meet the financiers, meet the legislators, meet the courts? Any last words?
Yeah, I think, if I understood your question correctly, if you looked at the overall landscape, I'm going to use data again, if you looked at how much in personal injury settlements are out there, whether the number I've heard, $40 to $60 billion a year is in personal injury settlement claims. It's a significant number. So let's say that's right. If you look at how much this industry actually funds, and I think the last panel talked about that as well, it's somewhat de minimis. So I don't believe that it's pervasive, and I'm not going to speak on behalf of the Bar Association, but I don't believe it's pervasive that it's used as a marketing tool. I mean, I would be remiss in saying that, but again, I'm not going to speak on their behalf. I'm looking at data saying it's somewhat de minimis in the grand scheme of things. It's a tool that helps those in time of need. Because not everyone who gets into, I've been in a plaintiff in a personal injury accident, an MVA, hit by a drunk driver. I didn't use it, right? But it's a tool that's there. But I think it's de minimis at this point.
Yeah. I don't think that this is for attorneys. I mean, the lending isn't for attorneys. This piece of legislation is going to the area where the money is given to the consumer to take care of personal needs outside of the lawsuit, to enable that person to continue on. That's what we're trying to do. Let's put it that way. And if we haven't plugged all the loopholes, let me know.
And I think it goes without saying, whether there's a vibrant funding community or not, the industry moves on, right? There'll be auto accidents, there'll be, a variety of personal injury claims. So for us, I think now the next step, we're only one generation removed from this industry's inception. I think to your point, make a very good point, I think we're kind of maybe already on our way.
Yeah.
And I think now codifying and how to find that balance to make sure there is a level playing field is so important.
Maria, could I just make one comment on that anecdote? So a long time ago, I was asked to do a whole bunch of CLE presentations on consumer litigation finance, mostly in upstate New York. I went to everywhere, Buffalo, Syracuse, Binghamton. I can tell you this, the only kind of constant in that tour I made was personal injury lawyers coming up to me telling me, in all due respect, they didn't want their clients doing this. I think that's still true. I think personal injury lawyers still see it as, for a variety of reasons, maybe rightly or wrongly, as not something that's in their interests.
I think that's true.
That's not true about the commercial side, but for consumer, I still think personal injury lawyers do not see this as something that they want. It's what their clients want.
Which I think on the practitioner side, we agree. That's why we say no more than we say yes, because we co-underwrite with the attorney. And so it's really in a very narrowly defined circumstance where funding is right. And so I think that's and it does provide a check and balance of sorts for legitimate players in the space.
So I want to thank all our panelists so much, beginning of a discussion, but also highly constructive in moving discussion about what legislation would be going forward. Hope we can have more discussion at lunch, and just thanks again to NYU for putting this together.
Thank you.